Work spats on social media sites. Believe it or not, it's happening all the time as more and more people log on to Facebook and other forums to air their dirty work laundry. But just what's safe to say? Attorney Eugene Pettis of the law firm Halixer, Pettis and Schwab is here to explain what all of us need to know. I had no idea that all of this was going on. So people are getting on Facebook or Twitter, and what are they doing?
Certainly. We're in a time where the lines between the workplace and the private time have been blurred. And what you say in your private time can have consequences in the workplace. It used to be where you would leave work and you would have your gripes and you would talk on the telephone. Now people are going to Facebook, Twitter, and putting those comments in an environment of the internet that can be disseminated to millions of people and have very damaging effect on the employer. So those are the consequences that employees and employers are now addressing.
What are some of the most, or at least one of the most egregious cases that you've heard of?
There are many across the country. One of the most egregious has been a sheriff out in California who went on Facebook and put pictures, uploading pictures as well as communication about skinny dipping and having a drunken binge, as well as discussing sexual orientation. He was fired for that conduct. It happened during his private time, but it had an impact on his position in the workplace.
So what should employees know about what they can and cannot do on Facebook as related to work?
And the employees, what they need to know really addresses the first question: what should employers do? Okay. And the employers need to have social media policies in place. Every employer, particularly those that employ dozens and hundreds and thousands of employees, must advise the employees in advance of what will and will not be accepted. You cannot have disparaging comments about co-workers. You cannot speak badly about the company. You cannot disclose confidential information. That information needs to be put out there in a policy up front. That policy needs to be communicated to the employees. And employees need to know that it's real. They need to adhere to that policy because there are consequences leading up to termination from the workplace for violation. Now,
I would imagine that when someone gets hauled in the court on something like this or up to HR, they probably say, hey, free speech, and I was on my own time. That's not good enough.
Not good enough. That's absolutely the first response. Do you have a reasonable expectation of privacy? The answer is most of us do. Under the Fourth Amendment, in a government relationship, that employee has a right to no unreasonable search and seizure. However, that may not be the case in the private sector. If you've been told in advance what will and will not be accepted in the workplace, then you cannot violate that policy. If you do, you're exposing yourself to termination.
And we have to wrap up, but what's the danger for a company? Because I would imagine if you really trash a company, it could cost them millions.
It could be, the damages could be endless. You can say certain things. You can disclose information that's highly confidential. You didn't intend to, but you were communicating with your coworker on an assignment in the workplace, doing a little bit of work at home, trying to do good. The consequences, you leaked a very important confidential document. It could be millions of dollars. So the lines have been blurred, but we must be careful, even in this time, to make sure that we're adhering to good policy and sound reason.
Attorney Pettis, thank you so much. And as my grandmother used to say, if you don't have anything good to say, you might not want to say anything at all, even on Facebook.
Absolutely.
For more legal advice, log on to halixerpettis.com or give them a call at 954-523-9922.